and then come to the finding on the basis of the materials available on record. You cannot remand it.
Yes.
Right? This is the duty of the first appellate court. What else? Second appellate court का कहाँ है इसमें?
नहीं तो ये तो क्या हाई कोर्ट सुप्रीम कोर्ट का ऑर्डर है?
हाँ सुप्रीम कोर्ट. फर्स्ट अपील हाई कोर्ट में भी होता है. ये फर्स्ट अपीलेट यहाँ पर हाई कोर्ट लेवल, यहाँ नहीं होता फर्स्ट अपील. होता है ना?
लेकिन प्रिंसिपल हैज बीन डिसाइडेड रिगार्डिंग द रिमांड लॉ.
देखिए आपको मालूम नहीं है, दोनों का प्रिंसिपल बिल्कुल अलग अलग है. सेकेंड अपील का प्रिंसिपल और फर्स्ट अपील का प्रिंसिपल बिल्कुल अलग है. दोनों एक तरह से नहीं चलते. ठीक है. दिस इज द जजमेंट यू आर डिलाइंग अपॉन.
फिर उसका देखा जाए, एक तो था सी देखा जाए.
किसका?
सब्सटेंशियल क्वेश्चन सी.
हाँ एक सेकंड, अभी आपका ये खत्म नहीं हुआ. आप उनको ये बताएंगे कि जो सब्सटेंशियल क्वेश्चन नंबर बी है उसका क्या फाइंडिंग ट्रायल कोर्ट का है और क्या फाइंडिंग आपकी
इस जजमेंट
एविडेंस पर. हमारे इस आपके केस में जो जजमेंट है ट्रायल कोर्ट का जो एविडेंस पर जो फाइंडिंग दिया है.
ट्रायल कोर्ट बोला था कि दैट इज नॉट एडमिसिबल इन एविडेंस, और अपीलेट कोर्ट बोला दैट इज एडमिसिबल इन.
क्या रीजन दिया है ट्रायल कोर्ट ने?
पारा 24 में देखा. पारा 24 ऑफ ट्रायल.
उसके पहले यहाँ पे आएंगे पैरा 22 में. पैरा 22. पैरा 22.
ये तो एग्रीमेंट 2 के बारे में बोला गया.
2 and 4 दोनों.
Which is the instrument
Section
of
64 of Evidence Act. Title suit.
ये जो एग्रीमेंट 2 को डिस्कार्ड किया था ऑन ग्राउंड की ट्रांसफर जो
एग्जिबिट 2 को जो डिस्कार्ड कर दिया है उसके बारे में हम लोग कोई चर्चा ना करें बिकॉज दैट फाइंडिंग हैज बिकम फाइनल अगेंस्ट यू. यू आर नॉट इन क्रॉस अपील. सेक्शन 64 पढ़िए. पैरा 22.
सेक्शन 46 के बारे में बोला गया.
पैरा 22 ऑफ द ट्रायल कोर्ट जजमेंट इंटरनल पेज 12.
Section 64 of the Evidence Act imposes a responsibility upon the party to prove his case by primary evidence as defined under Section 62 of the Indian Evidence Act. In the instant case, the document being relied upon by the plaintiff Exhibit 2 and Exhibit 4, and the document being issued in their favor, and hence they are accountable for its original. But the non-production of original will draw interference against the plaintiff themselves. The plaintiff had produced the certified copies of these two documents, even if the original thereof has been challenged by the defendant. Section 64 of the evidence provides that the document must be proved by the primary evidence, except in case of mention in
Section 65 and 66 are quoted. इसके बाद next में
इस secondary evidence के लिए describe किया हुआ.
Loss has to be proved. Whereas illustration B,
Section
सारे
104.
quotation.
Section 104.
इसमें बोल रहे हैं कि neither the partition deed and nor the sale deed are public documents.
हाँ,
ऐसा finding दी है, which
Yes.
is contrary to whatever January
Yes,
last.
yes. इसी को अपीलेट कोर्ट बोला है कि दैट इज एडमिसिबल इन एविडेंस।
That's right. इसके बाद यहाँ आइए, exhibit page number 16, internal page 16, para 22 का just, thus owners of proving.
Thus, onus of proving the loss of exhibit 2 and 4 lies upon the plaintiff, in which he miserable failed, and in absence of which the certified copy of the partition deed as well as the sale deed is not admissible in evidence. Further, the argument advanced by the learned counsel to the President that the burden of proving of forgery in the execution of these two documents lies on the defendant. This is correct finding,
Yes, आगे बढ़िए.
as the same has been pleaded by them is not maintainable in this regard. It is pertinent to mention here that the burden of proving the forgery been committed in execution of partition deed shall shift upon the defendant only when the plaintiff proves the said partition deed. The document filed itself is not admissible. Hence, the burden will not shift upon the defendant, and mere marking of the document does not mean that the said document has been admitted. Hence, the observation of the Honorable Apex is of the paramount consideration, wherein it is further held that however, we make it clear that more so admission of the secondary evidence does not amount to its proof. The genuineness, correctness, and existence of the document shall have to be established during the trial, and the trial court shall record the reason before relying on those secondary evidence.
That's right. This is the finding of the learned counsel. Para 24.
The plaintiff had miserably failed to state the ground as to why the lead secondary evidence to prove this case. Plaintiff, by means of oral evidence to PW1, PW has also tried to lead evidence beyond the pleading as well as the documents adduced by them, in as much as both of them, two witnesses during their chief, as stated that Ram Prasad Ram and Phagu Ram both obtained the settlement jointly in their favor. Whereas the case of the plaintiff is that the land was settled solely in the name of Ram Prasad Ram. Also, both of these two witnesses has deposed that the entire land been allocated to Ram Prasad Ram in the amicable partition was transferred by him in favor of the doubter. In my case, plaintiff had pleaded that the original is lost during the proceeding of 145 CRPC. 145 CRPC का जो order हुआ उस order में already that partition deed is described laws.
The what is there to show that that the deed was originally produced, the original deed was produced before the SDM court? Is there any evidence
That is mentioned in the order of the 145 CRPC.
that original deed has been produced?
That is described in the impugn order also.
Let us see. 145 का exhibit किए होंगे ना?
Exhibit
Exhibit number.
defendant का
Exhibit number.
exhibit A होगा. Exhibit A.
क्या डेट है एग्जिबिट ए का? क्या है?
Exhibit का डेट है 29/11/2009. Miscellaneous case number 237 of 1990.
ये रहा एग्जिबिट ए। बताइए कहाँ?
इसमें कोई भी एग्जिबिटेड डॉक्यूमेंट नहीं है, लेकिन डिस्क्राइब है और जहाँ पड़े हुए हैं।
तो ऐसा आपका क्या ही प्रूफ है और क्या ही एविडेंस है दैट इट वाज फाइल्ड ओवर देयर एंड इट हैज बीन डिस्क्लोज्ड? ठीक है, you have given secondary evidence that you have cited that it is admissible in evidence. But in the circumstances where its execution is disputed, then where is the original?
Execution is disputed, but that is registered in the registry office. Unless the contrary to that document is not produced by the appellant.
नेगेटिव कैसे प्रूव करें हो जाए?
ये genuine है। अगर genuine
अगर कोई बोले कि हम this was not signed by me, तो कौन साइन किया ये कौन प्रूव करेगा?
अब तो कोई कर ही नहीं सकता है।
कोई कर ही नहीं सकता।
सारे लोग मर गए।
ये सारे लोग मर गए, but there could be admitted signatures also. नहीं हो सकता किसी का admitted signature।
तो हमारा विटनेस बोलेगा कि उनका सिग्नेचर, इनका विटनेस बोलेगा कि इनका सिग्नेचर नहीं।
तो हैंडराइटिंग एक्सपर्ट के पास जाता ना ओरिजिनल आता तो।
वो ना 90 इलिटरेट आदमी है ये लोग से। यहाँ भी वकालतनामा दिया, ठेपा मार के देख लिया दोनों पार्टी।
एग्जिबिट 4 खाली देख लिया जाएगा।
और ये
एग्जिबिट 4 में सिग्नेचर है कि
डिस्प्यूट 1990 में
एग्जिबिट
शुरू हुआ
4 में यही डॉक्यूमेंट वहाँ पे फाइल हुआ था। ये ट्रायल कोर्ट का फाइंडिंग है कि जो यहाँ जो ट्रायल कोर्ट में फाइल हुआ वही डॉक्यूमेंट एग्जीक्यूटिव मजिस्ट्रेट के पास फाइल हुआ। ये ट्रायल कोर्ट का फाइंडिंग है, देख लिया जाएगा। ये ट्रायल कोर्ट ने लिखा है रनिंग पेज 14 ऑफ द ट्रायल कोर्ट जजमेंट 14 लास्ट बॉटम। But the plaintiffs have failed to produce any evidence in that. Further, it is also apparent from Exhibit 4 that the same copy was filed before SDM Nagoita. Same copy was filed. मतलब जो एग्जिबिट जो जिसको सर्टिफाइड कॉपी परपोर्टेड में सर्टिफाइड वही फाइल वहाँ भी की है। तो अंदर की बात इनका प्लीडिंग ही डिसेप्टिव नेचर ऑफ प्लीडिंग है। प्लीडिंग वैरीज हाउ दिस सूट कुड हैव बीन डिक्रीड।
देख लिए
इसका लॉस्ट का ही गलत है।
ये सब्सटेंशियल क्वेश्चन ऑफ लॉ नंबर कौन सा हुआ?
बी।
सी के बारे में क्या बोलना?
सी के बारे में कह रहे हैं कि जो रेवेन्यू रेंट रिसिप्ट इशूड ऑन द बेसिस ऑफ रजिस्टर्ड 2 ऑफ द अंचल ऑफिस। that is proof of possession. The plaintiff tenancy is continued.
कब से? एग्जिबिट 1 कब का है?
कब से है कि मेरे पास नहीं है, लेकिन बट दैट इज
एग्जिबिट 1 का डेट होगा ना?
एक्चुअली एग्जिबिट 1 मेरे पास है नहीं। एग्जिबिट
1 2007 का है, एग्जिबिट 1/1 भी 2007 का है, एग्जिबिट 1/2 भी 2007 का है। ठीक है, दिस इज द अर्लीस्ट रेंट रिसीट यू हैव,
यस,
राइट। सूट कब फाइल हुआ है? 2002 में,
2 का ड्यूरिंग पेंडेंसी का।
ड्यूरिंग पेंडेंसी आपका ये डॉक्यूमेंट आया है।
मेरा रेवेन्यू रेंट रिसीप्ट चल रहा है,
कब से?
इनका नहीं चल रहा है
भाई, कब से? दो ड्यूरिंग द
ये कब से
पेंडेंसी
चला?
ऑफ द सूट,
वो तो रजिस्टर्ड टू हम आए करेंगे तब पता चलेगा।
ड्यूरिंग द पेंडेंसी ऑफ द सूट 2007 में आपका रेवेन्यू रेंट रिसीट है एग्जिबिट 1, 1/1 एंड 1/2। सूट चल रहा है आपका 2002 से, तो उस समय जो भी रेंट रिसीट हो गया वो बाइंडिंग हो जाएगा किसी पर भी। उसके पहले का कोई रेंट रिसीट आप एग्जिबिट कराए हैं?
एग्जिबिट नहीं है, लेकिन एक तरफ मेरा रेंट रिसिप्ट है और ये अपना प्लीडिंग में दिए हैं कि मेरा रेंट रिसिप्ट है, लेकिन रेंट रिसिप्ट को प्रोड्यूस नहीं किया। तो प्रिंसिपल ऑफ प्रीपोंडरेंस भी तो लागू होगा और डिक्लेरेशन
प्रिंसिपल लागू होगा, लेकिन जो क्वेश्चन ऑफ लॉ है मेरे ऊपर तो बस उतना ही पर बाइंडिंग।
अब जहां तक एडमिसिबिलिटी का, उसको अब देखा जाए, सब्सटेंशियल क्वेश्चन को देखा जाए क्या बना है उसको। Whether the learned court of appeal below misdirected himself relying upon the exhibit 1, 1/1, 1/2, the rent receipt through not a document of a title in holding that the plaintiff has right title and possession। देखा ये चीज को भी देख लिया जाए कि इम्प्यूट ऑर्डर में क्या बोला गया है रेंट रिसिप्ट के बारे में।
इसके लिए पैरा 25 ट्रायल कोर्ट ने क्लियर लिखा है कि डू नॉट कंटेन द प्लॉट नंबर विथ रिस्पेक्ट टू व्हिच इट हैज बीन इशूड। ट्रायल कोर्ट का फाइंडिंग है, ये पार्टिकुलर से मेंशन नहीं।
पैरा नंबर
25
वो खाता नंबर से होगा उसको।
रनिंग पेज 38 ऑफ द ब्रीफ।
वो रसीद पर लिखा हुआ ऊपर खाता नंबर।
The plaintiffs have produced rent receipt when marked as exhibit 1, 1/1, 2/2, but the perusal they have disclosed the rent receipt does not contain the plot number with respect to which it has been issued. This is the finding of the fact. And trial and appellate court has not dealt it.
उस रसीद को एग्जिबिट 1 को देखा जाए और सिर्फ खाता नंबर है कि नहीं।
खाता नंबर के साथ प्लॉट नंबर भी होना चाहिए ना। खाता नंबर तो बहुत बड़ा होता है, खाता नंबर का एरिया भी बहुत बड़ा है।
The खाता contains several plots.
बिल्कुल रसीद में सारे प्लॉट्स डिस्क्राइब नहीं रहते।
अभी भी बहुत सारा क्या चीज सब प्रिजम्पशन
कैसे बात बोल रहे हैं?
हम खुद अपना रसीद अपना अगर उसको प्लॉट नंबर नहीं लगा
आपका रसीद गलत है तो इसका मतलब ये
इसका मतलब कानून भी अब गलत हो
पूरा
जाएगा।
लिखा रहता है सब चीज, खाता नंबर, प्लॉट नंबर, पार्ट अगर रहता है तो वो पार्ट भी लिखा रहता
हाँ, अंश भाग भी लिखा है।
है, अंश भाग भी लिखा रहता है।
हमारे पास तो बहुत पुराना रसीद है, खुद अपना भी रसीद हम बता रहे हैं कि उसमें नहीं लिखा, तो 4 प्लॉट लिख के छोड़ देता है।
पीछे बैक
बेटर है कि ठीक करवा दीजिए उसको।
वो संभव नहीं, रेवेन्यू डिपार्टमेंट को ठीक हम नहीं कर सकते ना। जिसको गवर्नमेंट ठीक नहीं कर सका, कोर्ट ठीक नहीं कर सका, उसको हम क्या करेंगे रेवेन्यू डिपार्टमेंट।
ये बोल रहे हैं बीइंग स्टेट में किनके पैनल में भी है,
हम खुद
बोल
बोलते
रहे
हैं
हैं
लॉर्डशिप इंटरनेट पे डाला जाए। नहीं हम स्टेट को बोलते हैं, सारे आदमी के कॉग्निजेंस में है, लेकिन कोई उस पर नहीं उठना चाहता। लॉर्डशिप डाला जाए झाड़ भूमि पे, किसी गांव का प्लॉट नंबर डाल के देखा जाए, खाता नंबर 00, प्लॉट नंबर 00 और ये
अब सब ऑनलाइन हो गया।
ये बियॉन्ड प्लीडिंग्स का क्या आपका है?
हाँ, बियॉन्ड प्लीडिंग्स का ही, बियॉन्ड प्लीडिंग्स में एविडेंस का ही है। एविडेंस
कौन सा एविडेंस है बियॉन्ड?
हाँ ये हम बता रहे हैं। 24 देखा जाए ट्रायल कोर्ट जजमेंट, उन्होंने यही लिखा है। इस सारे ट्रायल कोर्ट पहले द प्लेंटिफ्स हैव majorly failed to state the grounds
रिगार्डिंग अपील लिखा हुआ है।
why he led secondary evidence in proof of plaintiff by means of oral evidence through PW1 and has also tried to lead evidence beyond the plaintiff as well as documents reduce the in both of these two witnesses during the chief have stated that Ram Prasad Ram and Phagu Ram both obtained the settlement jointly in their favor, whereas the case of the plaintiff is that the land was settled solely in the name of Ram Prasad।
इनके प्लेंट में कहीं ऐसा नहीं था कि ओरिजिनल गुम हो गया है?
हैं?
प्लेंट में कहीं ऐसा नहीं था कि
हाँ, प्लेंट में था कि एसडीएम के यहाँ से गुम हुआ है। जबकि डॉक्यूमेंट जो फाइल किए हैं वो कंट्ररी टू
वो दूसरी बात है, तो बियॉन्ड प्लीडिंग कैसे बोलते हैं?
कंट्ररी टू प्लीडिंग हुआ ना, योर लेडीशिप कंट्ररी टू प्लीडिंग। इन्होंने कहा कि लॉस्ट हो गया एसडीएम के यहाँ से, तो जब जो डॉक्यूमेंट को एसडीएम के यहाँ प्रूफ कराए हैं वो भी सर्टिफाइड कॉपी है, वो भी ओरिजिनल नहीं है, इसलिए बियॉन्ड प्लीडिंग हुआ, एविडेंस बियॉन्ड प्लीडिंग हो गया, एविडेंस बियॉन्ड प्लीडिंग हो गया। अब विदाउट मीटिंग द रीजन, एक बस इतना ही मेरा काम सबमिशन है कि इन केस ऑफ संतोष हजारी which your lord ladyship has already dealt in 2nd April 28 of 2007 in a case of relying on case of विभिन्न आगेस, उसमें संतोष हजारी का केस का भी है, उसमें एक क्लियर फाइंडिंग है, द टास्क ऑफ एन appellate court affirming the finding of trial court is an easier one. This is not a case of affirming, this is a case of reversal. And regarding reversal, it is specific that the appellate court must come into close quarter with the reasoning assigned by the trial court.
कौन सा पेज पैराग्राफ?
ये संतोष हजारी का हम जजमेंट लाया, लेकिन इसको पैरा 19 में मैं हुजूर ने संतोष हजारी को रेफर किया है विभिन्न आगेस के जजमेंट के साथ, लेकिन हम संतोष हजारी से
हाँ उसमें
लेकिन संतोष हजारी देख लिया, संतोष हजारी मेरे पास है,
दे दीजिए।
संतोष हजारी का पैरा 15 में लिखा,
क्योंकि वो संतोष हजारी को डील करके ही कर रहे थे, तो
पैरा 15 में है।
नहीं ठीक है, दिस प्रिंसिपल इज वेल सेटल्ड।
क्योंकि इट इज ए केस ऑफ रिवर्सल, इट इज नॉट ए केस ऑफ एफर्मेंस, सो what is used task of the appellate
So
court?
under such circumstances, if the question number 1, but so far as other questions are concerned,
That is also a document is inadmissible, उस पर भी हम जजमेंट
नहीं वो नहीं बोलते। मेरा ये कहना है कि एविडेंस वाला पॉइंट तो हम लोग यहाँ पे डिसाइड कर सकते हैं ना भाई, ठीक है, पहला वाला पॉइंट नहीं डिसाइड करेंगे।
अगर रिमिट बैक होगा तब देन दे फर्स्ट appellate court will decide.
दोनों का अलग अलग फाइंडिंग है, लॉर्डशिप ही डिसाइड करेंगे, तो थर्ड एम्पायर को ये है
without meeting the reasonings of the trial.
नहीं, while dealing with secondary evidence, the appellate court has not met with the reasons of the trial court.
No, not matter. There is no finding on section 64, 65, which has been dealt by the trial court. Appellate court has ignored even this 65 and 64, 4 and 5.
देखिए, second appeal number 390 of 2017, heard the learned counsel appealing on behalf of the parties. This appeal was admitted for final hearing on 31/10/2018 on the following substantial questions. The counsel appealing on behalf of the appellant has submitted that in first substantial question of law, number A, the exhibit number has been wrongly mentioned as exhibit A. It ought to have been exhibit 4. This aspect of the matter has not been disputed by the learned counsel appearing on behalf of the respondents. Therefore, it is observed that the substantial question of law number A is to be decided in the context of exhibit 4 and not exhibit A, and accordingly the substantial question of law number A is to be read as under. A को quote करेंगे और exhibit 4 A की जगह exhibit 4 टाइप करेंगे. The counsel appearing on behalf of the appellant has submitted that the two documents were subject matter of consideration before the learned trial court. One was exhibit 2 and other was exhibit 4. So far as the claim of the plaintiffs in connection with the property involved in exhibit 2 is concerned, the same has been concluded against the plaintiff, inasmuch as the trial court as well as the appellate court have negated the claim of the plaintiff with respect to the property of 6 decimal of land contained in exhibit 2. He submits that no cross appeal has been filed, and therefore the finding with regard to exhibit 2 has become final and binding on the parties. With respect to Exhibit 4, in connection with which the substantial question of law has been framed, the Learned Counsel has submitted that the Learned Trial Court had cited numerous reasons to disbelieve Exhibit 4, but those reasons have not been met with by the Learned Appellate Court by reversing the judgment and decree passed by the Learned Trial Court. He has submitted that this also applies to the other substantial questions of law, including the rejection of secondary evidence by the Learned Trial Court, inasmuch as the plaintiff had tried to make out a specific case that the original sale deed was produced in the proceeding under section 144.
Produced लिखा है during course of proceeding. लिखा है.
proceeding रहेगा तभी तो during course होगा यार.
Produced in relation to proceeding under section 144 CRPC and was lost, but the Learned Trial Court recorded that the document which was produced before the SDO under section 144 है कि 145?
145.
145 of CRPC was the same document which was exhibited by the plaintiff before the Learned Trial Court. He has also submitted that the Learned Trial Court has also recorded that the execution of the document was being disputed by the defendants. He submits that the reasons for not accepting the secondary evidence in connection with Exhibit 4 has not been met by the Learned Appellate Court by accepting the secondary evidence. With respect to the substantial question number C, the Learned Counsel for the appellant has submitted that Exhibit 1, 1 by 1 and 1 by 2 were the rent receipts issued in the year 2007 and the suit was pending since 2002. He has also submitted that the Learned Trial Court has rejected the exhibits on the ground that the said exhibits did not give the details of the land for which the rent receipts were issued. He has submitted that the appellate court has not considered this aspect of the matter and has not returned any finding while relying upon Exhibit 1, 1 by 1 and 1 by 2. And thus the appellate court has not met with the reasons assigned by the Learned Trial Court in respect to all these three exhibits also. The Learned Court, with respect to substantial question number D, the Learned Counsel for the appellant has submitted that the Learned Appellate Court has, the Learned Trial Court had given specific finding that the plaintiff was trying to plead his case beyond pleadings, but this aspect of the matter has not been considered by the Learned Appellate Court. Rather, the Appellate Court has given the findings beyond pleadings. He submits that if the matter is remanded to the Learned Appellate Court in view of the judgment passed by Santosh Hazari within that report versus Purushottam Tiwari reported in bracket 2001 bracket 3 SCC 179 and also judgment passed by this court in essay number 28 of 2017, then all the questions of law which have been formulated are required to be revisited and the reasons which have been assigned by the Learned Trial Court to deal with each one of the matter is required to be considered by the Learned Appellate Court. He submits that in the case of judgment of reversal, it was an obligation under law is cast upon the appellate court to deal with the reasons which has been assigned by the learned trial court to decree to pass the judgment. इतना ही है आपका?
And first appellate court has to address both issue of law and facts, and no
The
oral
learned
evidence has
counsel
been.
has submitted that the first appellate court is duty bound to deal with both question of fact and law, and it is the final court so far as the question of fact is concerned. He has submitted that there are inconsistent findings on facts whereas compared to the trial court and that of the.
And no specific point for determination has been
He
formulated.
has also submitted that no specific point for
So-
determination has been
तो मैकेनिकल वे में
formulated.
लिखा हुआ है.
Rather, the learned, no specific point of determination has been formulated by the learned. That's all. The learned counsel appearing on behalf of the respondents on the other hand has vehemently opposed the prayer and has submitted that the judgment passed by this court in essay number 28 of 2017 and also the judgment passed by the Honorable Supreme Court in the case of Santosh Hazari does not apply to the facts and circumstances of this case. He has submitted that the learned appellate court has formulated specific point for determination and for that purpose he has referred to the internal page 8 of the appellate court judgment, wherein the appellate court has recorded that inverted comma, however there is no counter claim and therefore the only point required to be considered in this case is regarding rights of plaintiff's appellants, inverted comma. The learned counsel has submitted that so far as Exhibit 4 is concerned, everything depended upon the fact that the trial court had rendered Exhibit 4 inadmissible in evidence and the appellate court has held that the same was admissible in evidence. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court in the case reported in the case of Appaya versus Andimuthu, alias Angapandi and others, civil appeal number 14630 of 2015, decided on 20th of September 2023, to submit that the registered documents have been held to be public documents and they were admissible in evidence. He submits that it was not mandatory for the plaintiff to prove the original registered document Exhibit 4 to sustain his case. He has also submitted that it was the specific case of the plaintiff that the original was lost while the same was produced before the court in 145 proceedings. The learned counsel submits that not only the registered document was admissible in evidence, but the plaintiff had duly explained the reason for non-production of the original deed of partition. The learned counsel has further has also relied upon the judgment passed by Honorable Supreme Court in the case of Sirajuddin versus Jainab and others, passed in civil appeal number 1491 of 2023, decided on 27th of February 2023, to submit that the principle of remand has been dealt with by the Honorable Supreme Court in the said judgment. the learned counsel has further submitted that the rent receipts were rightly considered by the learned appellate court, and it is not necessary to give the exact plot number. Mentioning of khata number was itself sufficient to rely upon the exhibits to show that the plaintiffs were in possession of the property. He has further submitted that the findings of the appellate court was not beyond the pleadings, and therefore the substantial question number D also is fit to be answered in favor of the respondents. The learned counsel has in totality submitted that the appellate court has committed no illegality in passing the impugned judgment and reversing the decree, and all the substantial questions of law are fit to be answered in favor of the respondents, and this second appeal is fit to be dismissed. That's all. Arguments concluded. इसको judgment के लिए रखते हैं. I will put a date for the judgment.
One point
अब आपका कौन सा point?
बस बात नहीं. Original is not a public document. Section 65 में कहता है ट्रायल कोर्ट ने भी डील किया कि original is not a public document, so certified copy is not public document. Secondary evidence उसी का होगा जिसका original public document है. ये ट्रायल कोर्ट ने डील किया.
क्या चीज बोल रहे हैं?
Original CLD is not a public document, it is a private document, and certified copy of original, which is a public document. That certified copy is a public document. ये सेकेंडरी एविडेंस उसी का एडमिसिबल होगा 65 में. ये ट्रायल कोर्ट ने भी डेट किया इस पर. इसको हम सिर्फ अगर हम लोग ज़्यादा टाइम
सबमिशन में लिख देंगे. The learned counsel for the appellant has submitted that the original of the exhibit 4 is not a public document.
So it's certified is not public.
So its certified copy is also not a public.
इस पे हमारा रिप्लाई है कि सर्टिफाइड
आपका देख लीजिए.
नहीं, ये जो बोले उस डॉक्यूमेंट में कि दैट सर्टिफाइड डॉक्यूमेंट इज इशूड ऑन द बेसिस ऑफ रजिस्टर ऑफ रजिस्ट्री ऑफिस.
We'll see after.
For final so item 5, second appeal 188 of 2019.
This appeal was admitted for hearing on 6/8/24. A substantial question of law framed is whether the first appellate court, being the additional judicial commissioner to Ranchi, has committed a perversity by holding that Gair Majua armed land cannot be settled to anybody, being contrary to the settled principle of law, as has been held by Honorable Patna High Court in the case of Mohammed Hassan versus State of Bihar Court in 1970, Ilja 7, and which has been reiterated in the case of Maya Devi versus the State of Bihar
This
CWC 1.
is Gair Majua. The term
Gair
uses.
Majua armed.
Just a moment. This term has been partly written, it seems. This is Gair Majua
Sarna.
Son. Gair Majua Gair Majua land Sarna.
Was being used for the purpose of Sarna.
Yes.
So the question is whether Gair Majua armed land can be settled. Second question is regarding adverse possession. Whether the learned first appellate court committed perversity by not considering the plea of adverse possession of the plaintiff on the ground that the same can only be used as a shield.
Did you claim this particular property? You see, just a moment. Internal page 4 of the appellate court judgment. The land under suit is arm gair majuba land, a public land, and is in the nature of sarda land is admitted. Yes?
Yes. Admitted.
This is an admitted right. Secondly, you claimed settlement. When? What is the date of settlement?
I claim merits from the admitted facts. The exhibit is the Hatiyar. It has the land is recorded as Gair Mazua, Am, purpose Sarna, but in its possession of one Murat Sah for last 3 years. That is
3 years or 30 years?
3 years. So this record of rights was finally published in the year 1932. Possession of Murat Sahu was shown 3 years prior to date of publication.
That is 29.
Yes. Now this Murat Sahu Marat died leaving behind his son Ramchandra Sahu, who continued to be in possession even after vesting of the intermediary interest. Another very important fact, it is recorded under Khewat number 1 in the name of the ex-landlord, Maharaja of Jharkhand. Ramchandra Sahu, son of Murat Sahu Marat, bequeathed this property through a will to his sons Vishnu Shankar and Hira. They got a letters of administration of the will. Thereafter, Marat, the daughter-in-law of Ramchandra Sahu, on demise of Vishnu Shankar and Hira, transferred the property by a registered deed in the year 1981 to one Ram Kumar Jain. Ram Kumar Jain thereafter came in possession, got his name mutated, and in the year 87, by again a registered separate registered deed, sold and transferred the land to the plaintiffs. And thereafter they have got the name mutated. They have they are operating a petrol pump. Now, what had happened? The defendants, they claim to be a member of the political party. They used to demand, we make illegal demands of petrol and all that. In order to avoid that disturbance, firstly we lodged an FIR. Thereafter, we instituted this for a declaration of title and injunction.
What about the point of adverse possession? You are claiming title?
Claiming title as well as, if not through the
What
deed,
inconsistent?
that is permissible. I'll show. That is permissible.
Show me first that. Where is it? So go to judgment pages. So what do you
It's referring to 2019 volume 8 SCC 729.
2019.
Volume 8 SCC 729. This is the judgment by which Honorable Supreme Court held that adverse possession can also be used for declaration. Earlier,
That's right, there is no doubt.
yes. Now there are some judgments which are referred in this that I want to place to your lordship.
Is it permissible for you to take inconsistent?
Yes.
Because your the claim for adverse possession has not only been dismissed on the ground that it cannot be used both as shield and the sword, but it has also been dismissed on the ground that these are inconsistent.
Inconsistent, and but I'll just take your lordships to one judgment referred here, and this arises
आज
from
एक जजमेंट दे देते हैं, दो जजमेंट दे देते हैं, एक ये भी देते हैं 2000 देवाल वाला और एक और रीसेंट जजमेंट दे देते हैं. वो जो रीसेंट जजमेंट दे देते हैं, ग्रेवाल वाला मत दीजिए.
Can I take your lordships to para 11 of the judgment, page 745.
Yes. Yes.
Para 11. In Hitesh Chandra Bose versus Commissioner of Ranchi, a 3-judge bench of this court considered the question of adverse possession by plaintiff. The plaintiff had filed suit for declaration of title and recovery of possession based on hukumnama and adverse possession for more than 30 years. The trial court decreed the suit on both grounds, title as well as adverse possession. The plaintiff's appeal was allowed by this court. It was further observed that the court that adverse possession had been established by consistent course of conduct of the plaintiff in case possession was hostile and to the full knowledge of the municipality. Thus, the court could not have interfered with the finding as to adverse possession and could not have ordered remand of the case to judicial commissioner. The order of remand and proceedings thereafter were quashed. So, therefore, means I can maintain a stock based on title through an instrument as well as adverse possession.
No, merely because it has been decreed, that does not show us the principle of law which has been decided.
The suit was decreed, it has been mentioned,
What is
suit
the
was decreed on both the grounds.
See, the genuine principle is that you cannot have your adverse possession and title simultaneously, provided if you are claiming it from the same date. You are claiming that you are in possession of this property since 1929, and then you also claim adverse possession. What is the date on which you claim adverse possession?
Thus, in case my document is found to be, the title document is found to be defective, but my possession is in continuity since 1929. It is in continuity since 1929 through my predecessor in time.
This is not the principle. दिखाइए जरा, निकालें judgment.
Because in this case, which I have referred to, Lordship will find the plaintiff was claiming on basis of a hukumnama as well as adverse possession. Can I just refer to that judgment itself, where it has been discussed? In the suit, the plaintiff filed his claim in respect of plot number 1735, ward number 1 of Ranchi municipality, on the ground that he had acquired title to the land by virtue of hukumnama granted to him by the landlord as far back as 17/4/1912, which is Exhibit 18. Apart from question of title, plaintiff further pleaded that even if land belonged to the defendant municipality, he had acquired by prescription by being in possession of the land to the knowledge of the municipality for more than 30 years, that is, say from 1912 to 1957. Then lastly, the High Court thought that as the land in question consisted of portion of time or land appertaining thereto, adverse possession could not be proved. This view also seems to be wrong. If a person asserts hostile title even to a tank, which as claimed by the municipality belonged to it, and despite hostile assertions of title, no steps were taken by the owner, namely the municipality of this case, to evict the trespasser, his title by prescription would be complete after 30 years.
So according to you, what is the date on which you are claiming adverse possession?
That's
From
adverse possession of
counted from 1929.
time 1929. My predecessor in interest, Maratz, in 1959, by 1959 had acquired title by adverse possession because the land had vested.
I have given two more judgments of superior. जैसे एक इसके अलावा हो तो ये जजमेंट है ना, इसके अलावा एक और जजमेंट को याद let us see your pleading regarding adverse possession.
Yes.
Your case, specific case from the title,
Yes.
so you can just tell
Can I
us.
place it from the date or your lordships want me to
You
take it?
place it from the judgment. It
Judge-
must have been mentioned very clearly. Para number 2.
Yes. Page number 2, the lordship will find towards the bottom portion. both plaintiff Ramesh Kumar Jain and Pradeep Kumar Jain has got their name mutated and regularly paying taxes to Ranchi Municipal Corporation. Therefore, it shall appear that since before 1935, the property has been continuous uninterrupted pursuing custody of Mrut Sahu, then his two sons Vishnu Shankar Sahu, Hiralal Sahu, and thereafter the heirs of Vishnu Shankar Sahu, Hiralal Sahu, and then of Ram Kumar Jain and others, and finally of the plaintiff. Therefore, possession of plaintiff of the suit property shall be referable to and tagged with possession of Mrut Sahu, and consequently the erstwhile owners who had been in possession of the land in open assertion of hostile title to the same perfected the title and required.
Hostile against whom?
It's firstly against the landlord, then after Manas, since it had vested in the state on operation of Bihar Land Reforms Act, against the state.
But it has not been specifically mentioned because this particular land is a Sarna land.
But it was never used for Sarna. And there are
No, that is a separate thing.
there
Never
are,
used or, but when you say that it is hostile, then you, even the Sarna land, right, did not vest with the Zamindar after vesting. It did not go to the Zamindar. The Sarna land did not go to the Zamindar.
no,
It was only his personal properties.
Khewat is the name of the landlord. Khewat Malot to find is the
That's
name of the
right.
landlord.
That's right.
But it was used for the purpose of for the purpose of Sarna. Now, on vesting of the intermediary interest, once the land will vest in the state, being the superior landlord, and that is known. And the nature of land would, in my respectful submission, entry in record of rights is referable to the state of affairs existing there. It is not for all times to come.
So, is there any finding of fact that it was never used?
Yes,
for
yes,
Sarna
I'll
land?
place it. Yeah, I'll place that. I'll place it.
And therefore,
Admitted by the defendants. I'll place it.
who will admit it? Just merely because a land is not being used, it changes its nature.
Yes, my respectful submission, yes, and there are judgments to that effect. I'll place that. My respect, kindly take internal page 6 of the trial court judgment. Can I place one is DW1, internal page 6. Para 10, DW1 supported the case of defending in affidavit, whereas in cross-examination he stated disputed premises. One petrol pump is running and also one water is used. Petrol pump belongs to Ramesh Jain and others. He further stated no ritual ceremony used to take place over the suit land, rather it is done beside the suit land. In his DW2, in his affidavit, supported the case of defendant. In his cross-examination, he stated that since his childhood, he has seen petrol pump over the suit land. Disputed Khata plot number is recorded as Gair Manjua.
The point of adverse possession was not framed,
But it's not considered by the
not framed or not considered.
no issue was framed to that effect by the Learned Trial Court, and the First Appellate Court has just given just one paragraph finding that since it cannot be used as a shield, so it can be used as a shield but not sword. That is at para 17 of the Learned Appellate.
Did the learned appellate court frame any point of determination with regard to adverse possession?
But
Because the
that's-
trial court did not frame any such issue,
No, trial court.
nor recorded any such finding.
And Learned First Appellate Court has 3 points of consideration. But we'll find at para 8, internal page 5.
It's kindly read this.
Whether a public land recorded as Gair Manjua land can be held to be the title and legal possession of Murad Sahu on the ground of continuous possession for any period which is recorded as Sarna land for the purpose of offering rituals and religious work of scheduled community. Under this issue,
This is not adverse possession. This issue is again not adverse possession.
this is again a passing observation regarding adverse possession in para 17.
But this is not the way and
I
adverse
understand.
possession has to be
Listen.
decided.
It may be remanded because the issues have the Learned First Appellate Court has not even taken the deposition of the parties. is the final court of fact finding. There's no discussion with regard to what it's.
There is no discussion. This particular issue, whatever has been framed, is not even an issue of adverse possession. Let me see your plane for a moment.
Paragraphs. Para 13, 14, 15. And 16 also.
मैडम आप टाइम लेने के लिए तो नहीं खड़ी है ना? If you are doing so, this is absolutely not acceptable to this court. I will not accept this. Okay? कौन है आपके senior? Very good. I will not permit him to do. I will not permit him like this. Okay? He will not start all over again. यहाँ पे आधा घंटा से केस चल रहा है, निवान आपको देख के ही लग रहा है कि आपको कुछ नहीं पता है, न फाइल पढ़े न आपको कोई लेना देना है. You are representing whom? No, whom are you representing? State is the party. बहुत अच्छी बात है. Let that state go unrepresented. We don't bother about it, madam. You have taken the case very lightly, and your senior has taken it all the more lightly. You did not pray for a Passover. Yes.
Yes. Paragraph 13, 14, 15 of my plate is with regard to possession. Both the plaintiff, Mr. Ramesh Kumar Jain and Pradeep Kaur Jain, has got them immunized, enabling paying taxes to Rajasthan Corporation. That it is therefore it shall that since 1935 the property.
Where is it?
Para 14. Plate.
That therefore, yes.
Therefore, it shall appear that since before 1935 the property has been continuous unusual possession. Firstly, of Murat Sahu, then of his two sons, Vishnu Shankar Sahu, Hiralal Sahu, thereafter the heirs of Vishnu Shankar Sahu, Hiralal Sahu, and then of Ram Kumar Jain and others, finally of the plaintiff. Therefore, the possession of the plaintiff of the property shall be referable to and tagged with possession of Murat Sahu, and consequently asked by owners who had been in possession of the land in open assertion of hostile title to the same, perfected the title and acquired valid title to the property. Moreover, as has been stated above, the property in question was never used as sarna.
Most vague pleading, no specific pleading.
Near my case is that my vendors had acquired indefeasible title by way of adverse possession, even if there was an entry in record of rights. It was never used as sarna, as it has been also admitted by the defendant.
Since you are in illegal possession, it was never used as sarna. See, you are this particular property which is being used as sarna. This is for public use.
Not public
Right.
use, it is
Can
for
you-
use of a community,
No,
not public use.
Yes. Community by itself is for
Yes.
public
Now,
use
now,
only.
now that
Now, can this property be taken by way of adverse possession?
is
And
No.
and then when you say that it is adverse possession, it is not a merely because the paramount landlord is the state. That does not mean that this property, sarna property, will go to you by way of adverse possession.
my case, if I can. Whereas entry in record of rights, and again my submission is entry in record of rights is only relatable to the state of affairs as it was then when it was published. It is not for all times to come. And when I just place a judgment of this Honorable Patna on this issue. While framing substantial question of law, this was taken into consideration. Madhu sir, kindly take para 5.
Yes.
Having considered the matter, the first thing to be noted here is that there is no dispute that the land in the cadastral survey, which is over 100 years old, was shown as Gair Majua Khas or Kesari Hind. An entry in cadastral survey over 100 years old with regard to nature of land is not an entry for all times in future. It is an entry with regard to the existing state of affairs there. It does not preclude change nature of land through passage of time. It is not an entry which would hold good for all times to come and would bind all parties and not subject to change either by settlement or user. This merely because the cadastral survey, the land is shown as Gair Majua Khas or Kesari is not a determinative factor today. It only shows history. The next thing is whether the nature of land being as aforesaid, does law permit change? In my view, the state and its officials shall be harboring a misconception that once a land is recorded as Gair Majua or such that no settlement can be made by anyone at any point in time. The sooner this wrong impression is erased, the better it is, because of spaciously a lot of damage is being done. It is well settled judicially that such lands can be settled. That being
This
so,
is,
it cannot be said.
This is a judgment in writ petition.
Yes, one is BPLE proceedings.
Not this. We will not take this.
I can here usefully refer to judgment of this court in case of Chandeshwari Prasad Narayan.
You see, it is not your case that it was never Sarna. Your case is that it was.
It was recorded as Sarna in 1932 with a specific entry in remark column that it is in possession of Murad Shah. So therefore, if it is in possession of someone, how can it be used as a Sarna land?
Adjoining area is being used as.
Adjoining area is being used. I am not claiming the adjoining area.
That's right.
I am not claiming, and that defendant witnesses admit that it was never used as Sarna land. It is only the entry which is there. It was never used as Sarna land. There are other judgments again. One is on this slide that the lordships want me to place. I can read.
No, it is. So what is the nature of land now? It would be.
Now, when it's for last many years, it is a petrol pump is being operated, and I am paying holding tax to the municipality.
So that creates a right in
State has accepted me as a
municipality.
accepted as a user. Municipality as well as apart from holding tax, when its rent receipts are also being issued by the revenue department. Those are all exhibits.
This has been denied by the.
In WS, there is a mere denial.
You have merely asserted, they are merely denied. As simple as that. If you assert that since the year 1929 it was never used as a Sarna land, they have denied it.
And now, but they have admitted.
Your assertion has to come by a mere denial only because that is your assertion,
Yes,
simple assertion.
and defendant witnesses accept that it has never been used as Sarna land. Well, it's,
So this entry in record of right was disputed by you? No. That was not in dispute.
no, not in dispute.
Not in dispute.
Not in dispute, but again, the entry in record of rights, as I have submitted, is an entry with regard to the nature of land at that point of time. It was recorded as Sarna, but in possession of my predecessor in time. So it was not used as Sarna land. And my right, my suit has been dismissed merely on the ground that it is recorded as Sarna land.
What is the exhibit number of Khatian?
Exhibit 3.
Of Khatian.
3. Second post beat entry.
Kindly read it. It has been recorded as Sarna.
Sarna, in the remarks column, you also will find Kabja of Murad Shah.
Forceful
Kabja of for last 3 years.
Forceful possession.
Forceful possession, but not being dispossessed. There was no effort by the state or the ex-landlord as before 1950 to get recovery of possession within the prescribed period.
forceful possession, but they did not take any step for recovery of
For
possession.
recovery possession within the stipulated time.
So you were issued rent receipt when?
Yes.
What is the oldest rent receipt?
I purchased in
What is
80s.
the oldest rent receipt in connection with this property?
Yes.
There must be zamindari rent receipt. There must be rent receipt immediately after vesting.
What is my predecessor in title, that is from whom I have purchased, had got his name mutated.
When?
My entry was there in 21/10/87. It is after I had purchased.
That's it. There is no entry prior to that.
But I have stated in.
Was there any zamindari rent receipt issued
No.
to you? No, because you were in forceful possession. And after vesting, was the state ever recognized you as a tenant over the property?
Yes, I have pleaded.
Not pleaded. Show me the evidence that the rent receipt was being
Para 11 I
issued.
have pleaded Ram Kumar Jain, who is my vendor. Also got his name mutated in government revenue records, and rent was realized by the state of Bihar from them.
When? What is the date?
I have stressed what I have pleaded is my vendor got his name mutated, is pleaded in para 11. Now in the WS,
I want the date from the date from which you were giving the rent to the state of Bihar.
so far as the plaintiffs are concerned, from 87, and my vendor purchased it in 81.
So admittedly, the trial court did not frame any issue on adverse possession. Even the appellate court did not frame any issue on adverse possession. But there was a passing reference. Did it became any? There was just a passing reference that you cannot have both, and it cannot be used as a shield and a sword. And it was coupled with the observation that you cannot have both title and adverse
Yes.
possession. So this is with regard to the
Question number 2.
question number 2. So your submission with regard to question number 2 is that the matter is to be remanded.
Yes, because it has not been appreciated in the correct perspective.
It has no issue has been framed. What do you mean not appreciated at correct?
No issue.
At any stage, this issue was not framed. Just a minute. Essay number 188 of 2019, the learned counsel for Jharkhand, by referring to substantial question number 2, has submitted that the learned, neither the learned trial court nor the appellate court framed specific issue in connection with adverse possession, although the plaintiff had claimed adverse possession with respect to the property since 1929. In the records of right, the possession of predecessor in interest of the plaintiff was recorded as forceful possession. In the remarks column, that is shown as Gazban Kasba Kabza, that is forceful possession of one Murad Sahu since 3 years before the final publication of record of rights in 1935. Submits, it has also come to light that the property was admittedly recorded as Sarna. The learned counsel submits that the property was never used for the purposes of Sarna, and therefore the nature of the property was recorded as it stood at that point of time, and therefore it cannot, the nature of property with patches of time changed as the same was in possession of the plaintiffs. This is all?
Yes.
Or what about point number 1?
Point number 1, once I have referred to the judgment passed by Honorable Senator Patna High Court, referring to earlier judgments also. That means entry in record of rights is with regard to the existing state of affairs. It is not for all. It is not binding for all times to come.
A number of judgments have been referred
Yes.
to. Which all judgments are there? One is 1970 PLJR, other is this writ petition. This Patna High Court.
Patna.
This is one judgment you have cited. The other is
Sir, this. This was 1990 volume 1 BLGR page 445.
where is it? The other is this 1970 PLJR.
Yes, it has referred to this judgment has referred
No,
to
you
19.
just give me the judgment. When there are specific judgments referred to in the judgment, then we need to see the judgment itself. Where is this 1970? Respondent has got that judgment 1970.
Yes.
There are 4 judgments
Yes.
referred, 1970 Patna, then this writ petition of Patna High Court, then 1956 BLJR and 1990 volume 1 BLJR.
1990 volume 1 BLGR was given.
This is 1990 volume 1,
BLGR page
BLGR.
457.
okay, that you have given.
Yes.
What about 1956? Writ petition, you have 1956 and 1970.
Yes, 19. So I'll just pass it.
You have got that?
could not get it. Two copies are there.
I will simply say that
There are
these two judgments have not been placed before the court. I want these two judgments.
Yes.
It's basic. Referred to in the question of law and you don't get the judgment. What else the learned court could have done?
Because these judgments are referred.
No, maybe referred. Then,
Yeah.
then only one judgment should have been referred in the question of law. Then we would have seen only that judgment.
With this 1990 judgment which have passed, Your Lordship, the relevant paragraph is para 14.
Para 14. Yes.
Yet another division bench in CWC number 1004 of 93 Birla, Kumari Devi, the state of Jharkhand and others, decided on 2nd January 75 by dealing with the washing of orders passed in the 4H of the Act, wherein one of the reasons given by the authorities was that settlement of care movable land was not permissible in law and held as follows. The assumption of authorities that there could not be legal and valid settlement of care movable on land is not based on correct appreciation of law. It has been held several decisions of this court which have been referred to in Musama Hassan Bano versus State of Bihar 1959 ELGR 3 and 10 that there could be valid settlement of Garmentu armed lands as the landlord has the right to deal with them in such manner as he chooses so long he did not interfere with the customary or other legal rights of villages. It does appear that broad proposition of law, it is not correct to say that there cannot be settlement of Garmentu armed lands.
So it saves the general right of the public.
General right of the but here is a case where it was never used as such. Never used.
There is no
Adjoining area?
settlement. There is no settlement in your favor as
No
such.
settlement.
You are not claiming through any hukumnama,
No.
nor you are claiming through any settlement.
No.
You are claiming through adverse possession right from day one.
Yes.
Correct?
Correct. So my case is that my vendors or my predecessor in title, they were acquired title by way of adverse possession. And thereafter, once they acquired the title by way of adverse possession, they thereafter transferred the property to my vendor and thereafter
But that issue was never framed
yes, that was not fair.
at any stage.
And the defendants were the contesting defendants. The two defendants were contested. They say that, but it's in that deposition, one says that this property was never used as Sarna land. Adjoining portion is being used as Sarna land. And the other DW says that right from her childhood, she has seen a petrol pump over there. So meaning thereby that it was not used as a Sarna land. Of course, it is my responsibility to point out that the judgment that I placed was 2019 volume ACC 729, para 63. Ajira. When we consider the law of adverse possession as has been developed vis-a-vis to the property dedicated to public use, courts have looked to confer right by way of adverse possession. There are instances when such properties are encroached upon and plea of adverse possession raised. In such cases, on the land reserved for public utility, it is desirable that the right should not accrue. The law of adverse possession may cause harsh consequences, hence we constrain to observe that it would be advisable that concerning such properties dedicated to public cause, it is made clear the statute of limitation that no rights can inquire adverse possession. But my case is that it was never used for Sarna, it is not meant for any public utility, and I have continued to remain in possession through my predecessor title for more than 70 years. So it is not a public land for that matter.
What do you have to say? It is on the learned counsel for the appellant has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2019, bracket 8 SCC 729, and has submitted that the learned appellate court has wrongly observed that the plea of adverse possession can be raised only as a shield and not as sword. You are referring to any paragraph out of this?
Yes.
He has referred to paragraph number.
Para 11.
Para 11 of the aforesaid judgment, which in turn refers to the earlier judgment passed by the Honorable Supreme Court reported in bracket 1981, bracket close to SCC 103. However, the learned counsel has fairly referred to paragraph 63 of the same judgment to submit that in case of properties dedicated to public cause, there can be no accrual of right of adverse possession. He submits that the said observation would not come in the way of the petitioner, in the way of the appellant, as the property remained in possession of the predecessor in interest since 1929
And never
And-
used as sir, as
and
admitted
was
by the court.
never used as sarna since then, and therefore the same cannot be said to be of property of public utility. He has submitted that it has come in evidence that the land adjacent to the property claimed by the petitioner, by the appellant, was being used as sarna land. That's it.
And this judgment, which was 1981 judgment, that is with regard to a bond.
The learned counsel has also submitted that the judgment referred to in paragraph 11 of
Which
the
one?
of the aforesaid judgment was relating to a
A bond which the municipality was claiming, yet a decree was passed.
which the municipality was claiming, yet the decree was passed in favor of the person in possession by considering adverse possession. Yes, what do you have to say?
Yes. So now if I'm going
You
to
also
just-
don't have these judgments.
I have got copies of the two judgments.
Which one?
Two judgments is
1956,
yes and 70. No.
UBP 1956.
Yes. Now on this, so far as if leadership kindly allows, I will just
Judgment written.
I will refer to the plaint for a moment because it is not a simpliciter suit for injunction. The suit was filed, the plaint was filed in the year 2002. Now, before going to the pleadings made in the plaint, if the relief sought for is seen, that is at page 8, on declaration of plaintiff's title to the suit property described in schedule below, the defendants and all other villages were restrained by perpetual injunction from coming over the suit property and with the intention to forcibly occupy the same and damage the business structure. So they seek a relief for declaration of title, their title. Now therefore,
What was the basis for declaration of the title?
now their basis in the plaint, they say they admit that the land in question, that is the Gair Majrua Arm land, the entry in the survey records as it was prior to vesting of the state was as a Gair Majrua Arm land, and in possessory column it was written that it was forceful possession of the one Murad Saab, forceful possession. So the records of right, according to their own case, according to the revenue records, it shows that the nature of land is Gair Majrua Arm land. And so far as the person whose name was recorded, it was not recorded as a person, as a khatiyan holder, as a tenant, but he was shown in the possessory column as a person illegally possessing or forcibly possessing the said land. That is the entry. That is their own pleadings, that is their basis. Now they derive title. Their sale deed is of the year 1987. Their vendor sale deed is 81. Now the vendor got the sale deed from the legal heirs of that person whose name was shown as the person in illegal or forceful possession. So in that manner, the person who was in forceful possession, who was never recognized as a tenant under this, and either by the landlord or under the state after vesting, he did not have any title in any manner over the land in question. So their vendor, he did not have any title to transfer, because a person can transfer a title which he have, but if a person do not have a valid title, he cannot transfer a valid title. So that transfer does not give any kind of lawful right title interest to the plaintiffs or their predecessor in interest, their vendors. That is one thing, and this fact is undisputed. Now, rightly questions have been put by this honorable court about the recognition of that illegal possession by the Jamindar. The cases, I will come to those issue of law, the cases which they have referred, in those cases there was some kind of settlement, and those settlements were in question. Then those issues were decided, that whether a Gair Majurwa Aam land can be settled or not. Then it was decided that in a given factual matrix, even if a government had intention to settle a Gair Majurwa Aam land, and government had in mind that it was not required, then it was other thing. But here there is no settlement, there is no pleading that any settlement was made with their vendor's vendor, that any settlement was made, and so those judgments would not applicable in this case. And this is a case where a Gair Majurwa Aam land which has vested in the state, that has been transferred in the year 81 and 87, and which is being relied upon by the plaintiffs to seek a declaration from a court of law of their title. So there is no foundational fact for seeking a declaration of title. They have failed to prove that they have any derivative title from those sale deeds.
That's right. They are relying on adverse possession.
Now adverse possession there. Now the findings which the learned courts below has given, that is not a correct finding as on today, that it cannot be used as a sword. Now it has been held that yes, a person can sue and seek a declaration that he has a title and he has perfected by prescription by virtue of his long-standing.
But there is no such declaration sought for. He is seeking a declaration by stating that he is not claiming on any settlement.
He is not claiming on any
His entire claim is based on
sale deeds.
Hostile title.
First, he is now on that. We have a reply, and we contest the matter on this issue, that a person cannot take two contrary stands. That is not permissible. On the
He is not claiming title by any hukumnama, by settlement. No.
Not hukumnama, but by the sale deeds. By the sale
You
deeds.
see, the original title is forceful possession.
No,
So
now-
whatever, everybody gets title, whatever the vendor has.
Yes.
So vendor had forceful possession. So
But-
they got title of forceful possession. Now
No.
they are saying it is not a case that they are claiming through any hukumnama, and then the right devolved upon the purchaser. It is a specific case that they were under forceful possession as per the record of rights since 1929, and they continued in possession, and then different sale deeds were executed, and the successor in interest they acquired title. So what the successor in interest acquired was forceful possession. Now you tell us,
Yes.
this particular possession,
Yes.
can it become hostile,
Yes.
and can it be said to be adverse possession?
On that case, I will just refer to the plaintiff, because what case they have set up. Because a party will go into trial on basis of the pleadings.
Yes,
They have to lead evidence to substantiate their pleadings.
that's right.
They cannot even in evidence, they cannot go in their pleadings. If not, the receipt kindly allows, I will just read out. It is a small plaint. It will not take much time. From
Para 15.
para 15, that is the description about the adverse possession.
Yes.
That therefore the possession of the plaintiff over the suit property shall be referable and to and tagged with the possession of Murat Sahu, and consequently the erstwhile owners who had been in possession of the land in open assertion of a hostile title to the same perfected their title and acquired the valid title to the property. This is one pleading. Now what we are intending to convey, that this is their second point in their plaint. The first point which they say that they have derived title on basis of the sale deeds. For that purpose, if I am allowed to refer the plaint, had it been that they have pleaded only on basis of adverse possession, only on basis of prescription, by virtue of Article 27 to be read with Article 59, then perhaps we would have no reply on that. But now they are taking two pleas. First, they are saying that we have got title, we have got these sale deeds, then we have got our name mutated.
No, they do not claim title in any manner whatsoever.
Yes, if I am allowed to just read it from paragraph 3
Show
onwards.
us what is the initial basis of title that they are claiming.
Sale deed, they are saying the
Sale deed is subsequent.
sale deed is
Initial title of this Mantu Sahu, because Mantu Sahu is the vendor, right? He is a person who is
Murat Sahu.
named
Murat Sahu.
Murat Sahu,
Murat Sahu.
right? What is the title of Murat Sahu as per the plaint?
No, Murat Sahu as per the plaint, except though that illegal possession, he has no basis of no title.
Basis.
No basis of title.
So the entire, all the subsequent sale deeds are based on that illegal possession, right? So he is not claiming title on by virtue of any kind of settlement or hukumnama or followed by zamindari rent receipt or followed by rent receipt issued by the government. No, that is not their claim.
On that only one thing, they are basing their claim that they have got a sale deed. The reason for the cause of action which the soul, the basic cause of
You
action.
want to understand or you don't want to understand? They are claiming title from Mantu Sahu.
Through Murat Sahu.
Whatever, yeah, Murat Sahu.
Through Murat Sahu.
And
but
all the sale deeds are relatable to Murat Sahu.
Murat Sahu.
And
Now-
he had no title. Admittedly, he had no title.
No title. Now
It is not their case that he had some title and he has transferred.
No.
Their case is he was in illegal possession, he perfected his title by way of adverse possession, and subsequently whatever he had, he has transferred.
but there
That
for,
is their case.
for the purpose of adverse possession.
Correct? That's your case?
For the purpose of adverse possession, there cannot be any title deed which may be referred or claimed by the plaintiffs. Here is a case where they are referring to.
Do you want to say that adverse possession by itself is non-transferable?
And no, that adverse possession, so far adverse possession is concerned, the issue of transferable or hereditary, that is one thing. Here their case, what they have stated in the plaint, because they are seeking for a declaration of their title. So the basis of their plaint, because the cause of action, which is a bundle of facts, they have tried to show out a cause of action, basing that those sale deeds, their vendors sell deed, then their sale deed. And then on basis of that, subsequently they are saying that yes, this is something which is a alternate or contrary plea which they are taking in addition to the sale deed.
No.
If they
That is not correct, Mr. Anthony Banerjee. That is not correct. Their entire case is based on illegal possession. The root of the title is illegal possession. The entire plaint is based on illegal possession of Mantu Sahu.
yes, that is, they may just read out the plaints. They
No,
haven't
read out the
yes, the plaints that may be relevant from paragraph 3 onwards. Paragraph 2 onwards. That the revisional survey, plot number 19 under RS Khata 122 area 18 decimals of village Duwadi, PS Nampur was recorded as Gair Majua under Hayward number 1, which belongs to Maharaja Pratap Uday Nath Sahadev. That in remarks column of Khatia made in the year 1935, it has been mentioned that Murat Sahu, son of Bisundal Sahu, was in possession of the property for 3 years with Pakka well and house. That although the plot has been recorded and as Sarna, the same was never used for the purpose of Sarna. As a matter of fact, Murat Sahu was a famous manufacturer and trader of land, has his factory and establishment in the aforesaid plot number 19. That Murat Sahu died leaving behind his son Ramchandra Sahu, who came to hold and possess various land, including the land in suit, and remained in possession of the same till his death. Ramchandra Sahu died leaving behind a will bequeathing various properties, including the property in Shud, to his two sons, namely Bishun Sankar Sahu and Marilal Sahu, Hiralal Sahu. He executed and registered the will on 3/11/1959. So, Ramchandra Sahu is son of Murad Sahu and he is executing this will in favor of his sons, 1959. That after death of Ramchandra Sahu, his two sons applied for probate of the will, which was registered as a letter of administration, case number 73 of 66 of the Court of Judicial Commission Ranchi, during pendency of the same case. Both Bishun Sankar Sahu and Hiralal Sahu died, and therefore their heirs were substituted in the case. That the learned Court Judicial Commissioner granted the probate of the will on 5/5/1978. That the heirs of Bishun Sankar Sahu and Hiralal Sahu remained in possession of the property, including the property in suit, and thereafter, by registered deed of sale dated 12/9/81, they sold and transferred 15 decimals of land of plot number 19 to Ramkumar Jain and others. Ramkumar Jain and others, after purchase of the same, came to hold and possess the land as the owners thereof. This is also important. This Ramkumar Jain and others, after purchase of the same, came to hold and possess the land as the owners thereof. Paragraph. That the heirs of Ramchandra Sahu and others were mutated their names in the government revenue records with regard to the plot in suit, and rate was also realized by the state of Bihar.
There is no evidence to
No, yes, 10/11 there is no evidence.
No. 11 there is evidence.
Evidence is from 87. Plaintiffs.
87, Ramkumar Jain purchased in 87, I suppose.
81.
81.
81.
There is no evidence of 81.
No, there is evidence of it.
87, if I am correct, 87 is the mutation which they are referring in their case, and the documents which they have filed.
87 is a mutation. Exhibit.
Yes.
Exhibit B perhaps.
Rent receipts. Exhibit 6 is rent receipt in name of Ramkumar Jain, dated 3/9/1987.
Okay.
In fact, no mutation order is there. On correction slip of 87 is exhibit X/1.
This is 87 for the first time the rent.
Yes, 87.
In
That-
favor of Ramkumar Jain.
In favor of the Ramesh Kumar Jain, the present plaintiff.
There is, but it's, I don't
Present
know, a
plaintiff.
typographical error, but there is one exhibit 6. It is a rent receipt in name of Ram Kumar Jain.
Yes, I have seen one exhibit. There is one exhibit.
But-
6. What is the date?
It is of 87.
87.
87.
Because 87 as per their
Yes,
case.
For the
because
first time in exhibit 6. Correct?
it is, because thereafter on 31/10/87, the property was transferred to the
That's
plaintiffs.
There in page 15, there appears to be some kind of mistake because it shows Ramkumar Jain the plaintiff, 87 corrections. But Ramesh Kumar Jain is the plaintiff. Ramkumar Jain was his vendor, 81.
Yes.
So that is in respect of 3987 and prior to my purchase. The date is 3987.
Then 10 and 11 are concerned. Their averment about the mutation of their name on basis of the purchase. 10, 11. Then 12 is that Ramkumar Jain and others sold and transferred 11.5 decimals of land from out of plot number 19 to Ramesh Kumar Jain, the plaintiff number 1, by virtue of registered deed of sale dated 31/10/87, and by another registered deed of sale of the same date, they sold 2.5 decimals of the land of same plot 19 to Pradeep Kumar Jain, the plaintiff number 2. The plaintiffs therefore came to hold and possess 14 decimals of the land as the owner thereof. This is also important, their own assertion. On basis of this, title deeds, para 12, after para 9, para 12. Then they say about 1 decimals was left for road. 10, 12 are their readings about their derivative title, that both the then 13, both the plaintiff and the got their name mutated and regularly paying taxes to Ranchi Municipal Corporation. That's then they are again saying 19th property has been continuous and uninterrupted possession of Murad Sahu and then his two sons and thereafter heirs and other family. Therefore, the possession of plaintiff shall be referable to and tagged with the possession of Murad Sahu, and consequently the erstwhile owners who had been in possession of the land in open assertion to the hostile title to the same perfected their title and acquired the valid title to the property. So, here is a case which they have tried to set up as per their own pleadings in the plaint.
Yes.
There are 10 and 12. First, they have made a claim trying to make out cause of action or asserting their right that we are the owners by virtue of this purchase and we have come into possession by virtue of this sale deeds. That is their assertion. Their vendor also came, para 9 and para 12. So this is their specific case that in pursuance of that purchase they have came into possession. And so these sale deeds, one hand they claim on basis of the sale deeds, other hand adverse possession, which is not permissible. In that regard, we are also relying upon a judgment of the Honorable Apex Court, which is 2022 volume 10, SCC, page 217. If paragraph 7 and 8 are seen for a moment. Having gone through the improved judgment order passed by the High Court as well as the First Appellate Court and even that of the Learned Trial Court, original plaintiffs prayed for a declaration and claimed the title ownership on the basis of sale deed dated 31/8/67 Exhibit P1. Simultaneously, the plaintiffs also claimed the title by adverse possession. All the courts below have negated the claim of the original plaintiffs of ownership on the basis of registered sale deed dated 31/8/67 Exhibit P1. Therefore, the only claim on behalf of the plaintiff was the plea of adverse possession. So far as the plea of adverse possession is concerned, the High Court has specifically framed the substantial question of law reproduced herein above, and as such has held the same in favor of appellant, original defendant number 1. The High Court has specifically observed and held that plea of ownership based on sale deed and plea of adverse possession both are contrary to each other, and the plaintiffs cannot be permitted to take both the pleas at the same time. Therefore, even as per the High Court, the claim of the plaintiffs on the basis of the adverse possession was not tenable. In that view of the matter, and once the substantial question of adverse possession was held in favor of appellant to original defendant number 1, and the title ownership claimed on basis of the sale deed dated was negated by all courts below. Thereafter, the alleged possession of the plaintiffs could not have been protected by passing a decree of permanent injunction in favor of the plaintiffs. Under the circumstances, the High Court was materially urged in dismissing the appeal and confining the judgment and decree passed by the first appeal.
In the suit, there was no relief with regard to adverse possession. No relief as such.
Declaration of possession and
No, you just claimed title.
Title and injunction.
Title and injunction.
the cause of action is that they were coming to perhaps
That's right,
threatening my
whatever be the
possession.
cause
Yes.
of action, but there is no specific prayer with regard to.
Declaration of plaintiff's title to the suit property.
Yes. You just sought a declaration of your
Title.
title.
That was
And
the
injunction.
primary relief.
Title and injunction. So your primary relief, as what he wants to say, is that it was based on title deeds, not on the plea of adverse possession.
No. The declaration of title on basis of possession. Because it is admitted
No.
that I am in possession. They are coming and threatening to dispossess me or creating nuisance. That is the cause of action.
To all other villagers. It means that the villagers used to disturb,
Yes. Claiming to be, but it's some.
but not the state as such.
No, not this. But state was made a
And
party. Deputy Commissioner was a-
that's right. And villagers were being represented by private respondents.
Yes. I had filed an application under Order 1 late, which was allowed.
And villagers were made party.
Yes.
That's all. Say anything more?
Yes, one is on that. So for two issues have been framed. The first issue, the Honorable Court was asking for this 1956.
You don't have a copy.
I could not get a copy. I do not know why SCC online I could not get it. This was showing, but I could not get it for the purpose of downloading or printing these judgments. I will just give a clear photocopy of this.
Because BLGR is otherwise not readily available.
On the issue number 1, our pleading, our arguments or our contention will be that those judgments, that's Gair Majrua Amland could be settled, that would not apply in this case because it is not their case.
That it is not a case of
Settlement. Therefore, issue number 1, these judgments will not come into their aid. In all the cases, there were this case in hand which your ladyship is seeing. This was 4H proceedings. There was a 4H proceedings immediately after vesting for cancellation of the settlement. And there the court, after considering the facts, came to a finding no settlement has been made and there was no invalidity or illegality in the settlement. Therefore, it was recognized. In such a case, this finding was recorded. But here the very basis, there is no settlement. So they cannot take this plea. And therefore, my respectful submission would be that issue number 1, in the present facts, the issue number 1 has to be decided in a manner that since in this case there is no settlement of a Gair Majrua land, therefore those judgments will not be applicable in the present case, and in such circumstances, any transfer of title of the Gair Majrua land by any document would be not acceptable in law or will not have any force of law. That will be in respect of 1. And 2 is with regard to adverse position. There our reply will be only the same thing, that they cannot take 2 contrary pleas at the same time, which the Honorable Apex Court in 2022 has also considered. That in such a case, the Honorable Court should not have protected their possession when the Honorable Court has come to a finding that they do not have a title. And here is a case, they are basing on some title deeds, their specific pleadings on basis of this title deeds, that they have come into possession in pursuance of execution of that sale deeds, and then they got possession. So if they are not able to prove the validity of those titles, that title is passed to them through their vendors by those title deeds, then they cannot be protected by giving a declaration under the prescription of adverse possession. And more so, there is no relief also sought for.
You are representing the private respondents also?
Private respondents only. Private respondents only.
What about the state? State is absent.
Yes, Your Lordship.
You are absent. What do you have to say?
Your Lordship, in the written statement, it will record that the land in dispute of the divisional survey plot number so and so stand recorded as Gair Majrua Arm land and the class of land as Sadna. Thus, Your Lordship, this land is used for Adivasi community for the purpose of performing puja. The Sadna land is religious place of the Adivasi community. It came in the affidavit of the state.
Affidavit से क्या होगा? Binding बताइए. What do you have to say on the question of law? Did petition नहीं है ना? What do you have to say on the question of law? There are 2 questions of law which have been framed. What do you have to say on the questions of law? Read the first question of law. आप मत दीजिए. Don't read. What is the first question of law? Yes, read it.
Whether the learned first appellate court, being the additional judicial commissioner to Ranchi, has committed a perversity by holding that Gair Majrua Arm land cannot be settled to anybody, being contrary to the settled principle of law as has been held by the Honorable Patna High Court in the case of Mohammed Hassan versus the state of Bihar, reported in so and
What do you have to say to these judgments? You have read those judgments? Yes or no?
no, Your Lordship.
The learned counsel appearing on behalf of the respondents on the other hand has opposed the prayer and has submitted that and has submitted with respect to first substantial question of law, and has submitted that the judgments which have been referred to therein were either related to claim of the concerned person on the basis of settlement or hukumnama, and one or the other cases were relating to cancellation of such settlement. He has submitted that the plaintiff in the present case has stated in the plaint itself that the predecessor in interest of the plaintiff was in forceful possession of the land which was recorded as Sarna land. The Learned Counsel submits that in view of the aforesaid facts and circumstances, the judgments which has been relied upon by the appellant do not apply in their favor. He has also submitted that the property was recorded as Sarna land, which is for the use of the community at large and is used as place of worship for Adivasi. Adivasi is the correct word? For tribal
tribals would be the
for the tribal people. He has further submitted with respect to substantial question number 2. The Learned Counsel has submitted that the law is now well settled that plea of adverse possession can be claimed as a matter of shield as well as shore by virtue of the judgment referred to in substantial question of law, but the claim of adverse possession of the appellant has been rejected not only on the said ground but also on the ground that it was not open to the appellant to claim title as well as adverse possessions. He has submitted that the plaintiff was claiming title on the basis of sale deed, and it was asserted that the state had issued rent receipt to the vendors of the plaintiff. However, in the present case, the first rent receipt was issued only in the year 1987. He has submitted that the defendants had taken a plea that the rent receipt was issued in collusion. ये लिखा plea है आपका?
statement.
The Learned Counsel has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2022 10 SCC 217 and has referred to paragraph 7 thereof to submit that the plaintiff cannot claim title and also adverse possession simultaneously. The Learned Counsel has also relied upon the relief as prayed for by the plaintiff and has submitted that the plaintiff, by seeking declaration of the title against all other villagers and perpetual injunction against all other villagers from coming over to the suit property. During the course of arguments, it transpired that the private respondents herein were added as defendants by virtue of a petition filed under Order 108 of CPC, and they were representing the village community at large. Correct?
Yes.
The Learned Counsel has submitted that the substantial questions of law are fit to be answered in favor of the respondents. Mr. Banerjee has submitted that he is representing the village community.
Village, yes.
That is the private respondent.
Yes.
The Learned Counsel appearing on behalf of the state has also opposed the prayer of the appellant and has submitted that both the substantial question of law are fit to be answered against the appellant and in favor of the respondents. She has submitted that the property in question was Sarna land and was meant for the use of village community / public at large and was a place of worship. She has submitted that with the passage of time, the nature of land cannot change and the villagers had also opposed the prayer of the appellant. That's it.
Can you give a short input? Short.
Yes. Yes.
Second.
Okay, second.
And in my submission, so far as mutation part is concerned, that pleading is not there in written statement, which perhaps this honorable court has dictated that
Just a moment.
mutation.
Just a moment. Just a moment.
We have said that the sale deeds are fraudulently executed, but on mutation, it doesn't appear that we have.
Para number 14. पैरा नंबर 14 है कि नहीं है?
नहीं, हम कोर्ट का रिकॉर्ड से ही देखे थे, हमको और
दिखाइए।
नहीं
नहीं ऐसा नहीं, ऐसा कोई चीज आपका सबमिशन ऐसे नहीं है।
Yes, there is.
है?
Yes, yes.
This judgment has been relied to. I hear you post lunch. There are certain, Mr. Mittu, your certain matters are there for orders. We will take it up in the second half after his order of. I think I will take 10
5
minutes,
minutes,
5 minutes only, right? Because those matters are required to be tagged with some matters. Or what? You be there in the CA.